is Christopher Iannello Jr. Good morning to you.
Good morning.
I will chair the meeting this morning. We should be joined by the fellow councilors. They obviously have some constituent services in their neighborhood, but they should be on their way. At this point, I'd like to read a letter dated October 19, 2009, addressed to the Executive Council. Dear Councilors, I'm pleased to nominate Shannon Frison to the position of Associate Justice of the Boston Municipal Court, Roxbury Division. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. Sincerely, Deval Patrick, Governor. Before we hear from you, I know you have a lot of distinguished witnesses, and they have busy schedules, so we're going to hear from them first. And I do have a list of your witnesses. First, we'll hear from the Honorable Margaret Hinkle from the Suffolk Superior Court.
Good morning, Councilor. Where would you like me to
You can stand right next to the nominee.
I'm honored to be in front of you today in support of the nomination of Shannon Frison as a Justice of the Roxbury District Court. Since February of this year, I have served as the administrative judge in the business litigation section in Suffolk Superior Court. For the prior 4 years, I was the regional administrative justice for criminal business, otherwise known as the Raj in Suffolk County. And in that capacity, I also managed the homicide cases. It was with regard to that position that I came to know Attorney Frison. My knowledge of her is largely limited to her exemplary work in an enormously challenging homicide case, Commonwealth versus Carnes. In that case, the defendant was charged with the murder of 4 young men. Attorney Frison represented the defendant in that case. I managed the case from its arraignment until the time of trial. In that connection, I had ample opportunity over time to see Attorney Frison's relationship with all of the employees of the court system, and I think I can attest to the fact that she handles her relationship with court employees with equanimity, with firmness, and with strength, which will serve her well as a judge. I did not preside over the trial in that case. My colleague, Justice Patrick Brady, did. However, unfortunately, once the case reached the deliberations process, he became ill, and I had to take over on an emergency basis during complex and difficult jury deliberations. So I had an opportunity then to observe Attorney Frison very closely at a time of enormous tenseness where there was extensive media coverage of the case. I also presided over the sentencing of that case. And it is in connection with, I think, those experiences that I believe that I can talk about the qualities which will make her an effective judge in the Roxbury District Court. First, as her academic record suggests, she is highly intelligent. She writes well, in my experience, and she is a persuasive oral advocate. She is calm and she is tempered in times of stress. She handled, as I said earlier, the pressure of this difficult case with equanimity and with firmness. Perhaps because of her military background, which quite frankly I did not know about at the time, she seemed to me to have nerves of steel. This case had an enormous amount of media coverage, and it had also a situation where at any time in the courtroom there were large numbers of individuals who were representatives of the victims' families and representatives of the defendant's family, and she seemed to be communicating in a way which was sensitive and clear to all those around her. I have been a trial court judge, as some of you in this room know, for a very long time, for almost 17 years. Over that time, I think I have come to understand how important it is for a judge to have certain qualities. Fundamentally, to be able to listen well, Shannon has that quality, to be able to communicate clearly to those who are in front of her. She seems to me to display that quality, to handle matters fairly and effectively, and to make decisions promptly. I am confident that she possesses those qualities. I think they will serve her in good stead. I respectfully ask that you confirm her. Do you have any questions?
No questions. Thank you very much. Nice to see you again, Judge.
Good to see you.
Next we'll hear from Ellen Zecca from Burns and Levinson.
Good morning. Thank you very much for hearing from us today. I think, I know I speak for myself, that I feel quite honored to be here in front of you to support Shannon Frison's nomination to the bench. I'm a partner at Burns and Levinson, and prior to that was at Dwyer & Calora, which is the time that I met and worked with Shannon Frison. I will tell you that when I first received a call about her potential nomination to the bench, I had not been aware that she was applying, and my first reaction was that this was simply perfect. It was perfect because she had displayed in my relationship with her the very qualities that I seek when I go before the court. I want, when I go before the court, to have someone who is even-tempered, listens well, wants to know the law, is demanding of counsel in front of her or him. And I have found in my interactions with Shannon that she is precisely that kind of person. And I'd like to back up. I was on the hiring committee at Dwyer & Calora when Shannon came to work there. And I had occasion, as I often did, to talk to references. And I remember to this day the tenor of the references I received on Shannon Frison. One was from a mentor of hers in Chicago, another from a mentor and supervisor in the military. Both spoke in nothing but superlative terms, not only of her skills, but of her kindness, not only of her ability to listen, but of her ability to be resolute and move forward. I thought to myself, frankly, when we selected out of the number of people Shannon to come to the front, that it would be interesting to watch, because often there's a little bit of hyperbole in what you hear. There was none. Shannon is what the billing is. I had an opportunity to work with her both on a criminal case that was fairly high stakes for our client and on a long civil case. And the civil case I will focus on was a case that mattered a lot to me. I'd started it when I was a very junior lawyer. I tended to it over many years, and as it was coming to trial, I asked Shannon to join me. As those of you who have participated in trials know, that last moment before a trial is intense. And asking someone to get up to speed in a case that had existed at that point for, I think, 5, 6, 7 years was an extraordinary request. She did it well. And the measure of that is not just my words today, but it is what we did at trial. I felt so confident in her depth of understanding of the facts, the witnesses, the legal issues, that I divided the case with her equally, because I knew, in fact, there were things she could do that I might not be able to. And I will draw your attention to one moment, because it tells you something about what she as a trial judge will be able to accomplish. There was a hotly contested issue about a witness, a particular witness, that we wanted in, the other side wanted not so much in. And the other side, I should note, was represented by Joan Lucas, so this was very able counsel we were opposite. And we got the witness in, but it had to be a very deft examination. And I knew that one question over a line would draw an objection and potentially lose the witness for us in the case. She was a very important witness. Shannon got the information we needed into the case without drawing a single objection. That was tough. And what it showed me, and what I observed when I watched her at trial, is she has a very finely tuned sense of the rules of evidence, of what a courtroom proceeding is supposed to be about, and how to conduct herself in it. Those are things that we need on the bench, that I, as a trial lawyer, hope for, and that I know the Commonwealth will receive when Shannon joins the bench, if you choose to nominate her. Now, I want to talk for a moment about Shannon as my colleague. Trials are intense experiences, and I've come to appreciate that they are for judges and for the litigants and for the lawyers alike. She approached this long trial we handled together with an unbelievable sense of calm, with an ability to listen well to witnesses and to me and to everyone involved in the case, and with a very shrewd sense of how to handle tough decisions. She is a quick study, she is kind, she is resolute once she makes a decision. Now, in the office, we worked a couple doors down from each other for a number of years. I will tell you, and I say this with some embarrassment, humility, Shannon was the favorite in the office. Staff, attorneys alike. And she was the favorite, not just because she's nice, she is, but because she commands respect and she gives respect to all in an office setting. She's not someone who simply manages up and does not deal well with everyone else in an organization. She deals with people with great respect, and by so doing, at least it was my observation, she got the best out of fellow lawyers, she got the best out of our staff, and she commanded the best of everyone around her. I think we would be lucky to have her on the bench, and I urge you to accept her nomination. Thank you.
Thank you. Just have one quick question. Now, you talked about that case you had with Joan. Joan, big law firm in Boston. What happens in the district court? Give me a sense how Shannon would be. Now you have the assistant district attorney going against this sole practitioner. Doesn't have all the staff that your firm, doesn't have all the staff, Joan, handles or whatever. I hear so many complaints from lawyers where, the assistant district attorney, well, in this case it's district court, so much paperwork, and or if there's a continuance and I gotta take my kids on vacation, well, guess what? In your case, you had Shannon. You called her to help me out. There's so many sole practitioners, you don't have to worry about paying the rent, paying the electric bill, the one secretary that they have. Will she be sensitive, if you know, because you seem to know pretty well, if that sole practitioner comes in and says, I need a continuance, because, the paper, I don't know how he or she's going to say it this way, but I need more time. Give me a sense about her sensitivity and what she would be like in those situations.
My sense and my strong sense of Shannon is that she will listen well. And what that means is she will understand from everybody. I think she is not someone who pays a whole lot of attention to somebody's station or whether they're from a fancy firm or they're a sole practitioner. She herself has been a sole practitioner. She made that decision to go out. She's got a lot of guts. And so she knows what it takes to run a practice. She knows what it takes to be part of a larger practice. And she's experienced both. And my strong sense of Shannon Frison is that she will listen well. She'll understand and appreciate the real pressures on practitioners. She will push people appropriately to keep their eye on the ball and understand that there are litigants who need their disputes resolved. And so I think she will be respectful but firm with practitioners in front of her, and she will not be swayed by whether they come from a fancy firm or an honest place.
Thank you very much. Thank you. No, well said. Thank you. I'd like to introduce Marilyn Petito-Devaney, and to my left here, Councilor Thomas Merrigan and Councilor Thomas Foley. Next, we'll hear from Assistant District Attorney Jeremy Bucci.
Hi. Thank you very much for holding this hearing. It's with great honor that I stand here and represent to you that my experiences with Attorney Frison have led me to this moment with a great deal of pride. I would like to acknowledge Councilor Merrigan's contribution to the part of the state where I grew up, and in fact, it's by sitting in his courtroom several times that I decided I made the decision to go to law school, and I am where I am today. So it's a profound honor that I stand here before you to make this recommendation.
Thank you.
I am currently a member of the Suffolk County District Attorney's Office. I've been in that capacity since 2001. I am currently the Chief of the Narcotics and Asset Forfeiture Unit. During my tenure with the office, I've had an opportunity to appear before all of the district courts in Suffolk County. I've appeared a few times before the Massachusetts Court of Appeals, and right now I appear daily in front of the Suffolk Superior Court. Over the last 8 years, I've handled thousands and thousands of cases, and I've dealt with dozens and dozens, perhaps hundreds of defense attorneys, and dozens of judges. I've had an opportunity to lecture on topics with attorneys and on a wide range of issues, from appeals to juvenile justice and a variety of topics in narcotics. Most recently, I've also had an opportunity to lecture alongside Attorney Frison as about expert witnesses in drug cases. I met Attorney Frison in 2008. During that time, I've had an opportunity to both work on cases with her and supervise attorneys that are working on cases with her. That has led me to get to know Attorney Frison, and I'm happy to call her, in addition to a colleague or friend. She advocates zealously for her clients, and what that means is whether she's securing a favorable verdict for her client at trial, or doing the more important task, perhaps the more common task of approaching a busy prosecutor in a city and understanding how to approach that prosecutor about the case that she's handling. She does it excellently. She does it without any hesitation, and she's competent in all areas where she has to approach those sensitive and oftentimes complex issues. I've also been impressed with her legal acumen. She's at all times, as long as we're not talking about the facts of the case, I always agree with her legal analysis. She knows the law, she understands the law, and she cuts right to the precise issue that is important to the resolution of the case. That isn't something to be taken for granted, because not everybody always gets that. In a small town in western Massachusetts, and having several friends and family, in fact my brother serving in the military in Germany and again in the Iraq War, I have profound respect and admiration for the important contributions she's made to the country. I also would like to take an opportunity to express my admiration for her contributions to the Commonwealth in her role as a prosecutor in the Quincy District Court and as a defense counsel, formidable defense counsel and member of the bar over the last little over 10 years. I believe that those experiences that she has had have contributed to making her the person that she is today. And aside from the supreme qualifications she has, the educational background, as Justice Hinkle noted, and in my experience, her ability to perform in the courtroom, what she has, the plus factor that she has, that shouldn't be underestimated, because I think that those qualifications alone, although they qualify a person, I think, on paper to be a judge, the thing that we should be looking for when we're nominating judges is temperament. The ability to possess those characteristics and recognize that you are a human being dealing with other human beings, both that are parties in a matter before you, and the attorneys themselves are human beings and are parties in matters before you. Her temperament is perfect for that position because, as has been noted by her colleagues, she doesn't get rattled. She doesn't take for granted that the other person is only focused on that case. She recognizes the whole person. And so while all of those characteristics that make up a good judge, those qualifications are present and supremely present with Attorney Frison, she's also somebody that I think will be perfectly suited to sit, especially in Roxbury District Court, where the demands are so intense on a day-to-day basis, and the stakes are so high for many of the people that appear before that court, many of the prosecutors that oftentimes have to suffer in that court, and sole practitioners that suffer in that court. She would be perfectly suited. Those questions that you asked previously about whether she would be able to handle those situations, it's without hesitation. I would answer affirmatively. She can handle that. She's perfectly suited for that. Thank you for the opportunity.
Thank you. Any questions, Councilman Merrigan?
It's very nice to see it. Somebody who's really doing a great job down here. Sometimes when people get to the bench, they change. The names of the job, the properties of the authority and stature and so forth. seen that beforehand. And do you have any thoughts about whether or not Attorney Frison would sort of be somebody who could be susceptible to that kind of sliding?
I couldn't stand here if I thought that would be a possibility. Her experiences in the military, I'm absolutely certain, have contributed to her even temperament and her ability to see things fairly. She prosecuted while she was in the military. She prosecuted out here in the district court, in the very busy district court of Quincy. And she's also represented a number of clients as a defense attorney.
It's about sort of an innate humility that sort of somebody doesn't lose just because they become a judge.
Precisely. And I stand here very proudly and confidently to tell you that I believe she possesses exactly what I
Well, your thoughts and support really was well spoken.
Thank you.
One quick question. Now, you said that, and you look at her resume, I mean, clearly she's a bright individual. You said she's bright. We sort of know that. She's a friend of yours, which is, she's worked in the Norfolk District Attorney's Office prosecuting cases. She's worked on the other side. She had a sole practitioner for the last few years. I'm sure this wouldn't happen in Dan Conley's office. He's a friend of mine. I'm sure he trains his people well. What do you think, what type of judge would she be? Let's give an example, district court, okay? A lot of times, some judges let the attorneys try the cases. Sometimes, and you may not know this, and I'll ask Attorney Frison, sometimes the judges like to interject, okay? What happens in a case? Roxbury District Court, one of the busiest courts in the Commonwealth. And now we have a district attorney, let's say operating under, he's inundated with this case, that case, he's running around with all his files falling down, and he forgot to put in a public way. Okay? Some judges in the Commonwealth, motion to read the defendant rests, I should say, the prosecution rests, what I meant to say. Defense attorney makes a motion, I don't do any of that, I haven't been in court in years, but motion for required finding not guilty, that may not be the term. Is Judge Frison going to be that type of judge? And you may not know it, I will ask her, going to reopen the case. I know you as a district attorney would like to reopen the case and, let the prosecutor put in the public way. In other words, the judge's interjection herself into the case and not let the attorneys try the case. Give me a sense of what type of judge do you think Judge Frison would be?
I think she would look at the case individually for what it was and determine whether it was, as you drew the picture of a busy prosecutor that overlooked it and there was ample time and the witnesses were still there in the courthouse. She may, and the case law is clearly there and allows for that. Knowing her, I would expect her to be deferential to the advocates that are working extremely hard to present their case, to make that argument, look at the law, and make the right decision based on the facts, and again, the human beings that are appearing before her.
Yeah. Thank you for your answer. I would hope that you would do the opposite, to be honest with you. My feeling, and I ask this to a lot of judges, and it's 50-50. So many judges, I don't even know, I don't keep a poll, but so many come in here and says, hey, that's not my job. Let the attorneys put on their case, and if they botch it, that's life. Go to the next case. It may not be fair, but life isn't fair. The judge isn't there, at least in my opinion, and I appreciate your answer, by the way. The judge isn't there to try the case. Okay, but I do appreciate it.
And I think that there are differences in if the person is willfully neglectful or unorganized and doesn't deserve
Well, guess what? Conley shouldn't have hired that person. All right, thank you very much.
Thank you.
Next we'll hear from Attorney Lauren O'Connor.
Graduated.
Yeah.
I'm going to take my glasses off.
Sure.
I'm not an attorney yet.
Yeah, I saw that afterwards. I saw that. Well, we'll make you work for that.
Good morning. My name is Lauren O'Connor. I've been secretary for more years than I care to admit. I have worked at the Federal Bureau of Investigation, the Drug Enforcement Administration, the U.S. Attorney's Office, and for a sole practitioner by the name of Kevin O'Day.
whom you may now know as the Honorable Kevin O'Day, a District Court Judge in Region 2. For the last 8 years, I've been employed at the law firm of Dwyer and Kalora in Boston. That is where I met Shannon Frison, a young, energetic associate who immediately impressed me with her smile and gentle demeanor. I was assigned to assist Shannon with her caseload, and over a 6-year period, we became great co-workers and friends. She juggled several challenging criminal and civil cases, and I really enjoyed working with her and getting to know her clients. I felt that we worked in tandem and complemented each other's personality and work ethic. She would give me an assignment and let me follow through with it without a lot of supervision. She trusted my judgment, and I in turn admired her abilities as an attorney. She never made me feel like I worked for her, but rather that I worked with her. It was because of the confidence that she instilled in me and our mutual respect for each other that we made such a good team. In all that time, I never heard Shannon raise her voice or get upset. She handled distress beautifully. Her temperament never changed, even when she was on trial. She was soft-spoken, yet firm, and most of all, she was always determined to get the best result for her clients. And her clients loved her, too. I could tell when I talked with them on the phone how much they trusted her and how grateful they were that they had found such a caring and knowledgeable attorney to represent them. Only 3 months after I started working at Dwyer and Kalora, my mother passed away. Shannon sent me the most beautiful bouquet of white roses that I've ever seen. I was really overwhelmed by this gesture, considering that she hadn't known me for very long. It made me realize what a genuinely kind and thoughtful person she was. She was well liked by everyone at the firm. Her easygoing nature and approachability made her a favorite among the staff. You would often see coworkers in her office seeking her advice on how to handle a problem, whether work-related or personal. She would always listen. Shannon has a love for football and was very involved with the Women's Professional Football League when we worked together. And another thing she loves is being a Marine and serving this country. When she would go away on active duty, we would keep in touch about what was going on back in the office, and she'd tell me about her military cases, which I thought were fascinating. She was well respected by her military peers, some of whom I had a chance to speak with on occasion, and they praised her leadership skills. I've come to know a lot of people during my secretarial career, but few have impressed me as much as Shannon. I know she has the right stuff to be a judge for our Commonwealth. She is kind, considerate, and unflappable. I know she will be fair-minded and take her judicial duties very seriously. I also know that you will like having her around as much as I did. I do miss working with her, but if I've lost her to the bench, then we have all gained something quite special. Thank you for letting me speak about my friend.
Thank you very much.
Thank you.
Excuse me,
I just
Councilor
want to
Bain,
say
has a question.
thank you for your testimony. It was very heartfelt, and I have to tell you that Attorney Frison spoke so highly of you. I feel like I know you.
Oh, thank you
It's
so much.
really nice.
Thank you. Yeah, that's fine.
Thank you.
That will conclude the witnesses in support of the nomination of Shannon Frison. Is there anyone here in opposition to the appointment of Shannon Frison?
Mr. Chairman, may I speak?
Yes, sir. You can stand over there and identify yourself. Thank you.
Good morning, councilors. The councilors know me. I'll identify myself to the guests. My name is Joe FrisonHearingOctober282011878. I'm the chair of the Fathers of Coalition. And unfortunately, I find myself in the position of being half in and half out. I must speak in opposition to the nominee. But I want to say that I appreciate and do not in any way take any issue with the character of the nominee or the judicial experience. I'd like to just speak more to the question of judicial philosophy. As the council knows, and as the nominee knows, we sent the questionnaire to the nominee regarding our questions regarding her judicial views on the matter of 209As and issues of importance to men and fathers in the courts. As with previous nominees, we did not receive a response, so we're very interested in hearing what the council has to ask the witness today, and we'll make a final determination as to whether we support or not, or remain neutral to the nominee. But at this stage, the nominee is a blank slate as far as our issues are concerned, so we must say that we oppose the nominee at this point in time. But we think it's important that our issues are addressed. We don't think our efforts in this regard is in any way used to derail the council in its forum, but we think that it's an augmentation of what the council needs to do. We hope the council views it in that light. We hope the council will take our issues, ask the nominee the questions as we presented them, and get some serious answers that we can analyze and take a position on.
Thank you very much. Councilor Bernay.
Joe, thank you for coming.
Sure.
You know, I'm always sensitive to your position. I want you to know, I hope you realize that the nominee was told that she was going to have this hearing, and she received a notice to have her questionnaire filled and submitted in 8 days. Guess what? That she got it 6 days before that. So she's supposed to do it 8 days before. So it's so rushed. The nominee, I've said it many times publicly, the nominee should be given 2 weeks before hearing. And in all due respect, they're asking the nominee to do a questionnaire 2 days before they get it. They're supposed to submit it. And you know, that's ridiculous.
If I may, Council,
And so could I just say one thing? I don't know the circumstances, but I'm just saying, given that, they have to do all that and get that all done. I don't know how anyone, given that time, 5 or 6 days that they know they're going to be having a hearing, can respond to your questionnaire and everyone. And I'm not, you know, I don't know the circumstances, but I want you to know, because a lot of people don't know that. And I've been very vocal for years about that councilors should schedule hearings 2 weeks ahead. So it gives the nominee the time to do a thoughtful process for their questionnaire. The questionnaire is done in penalty of perjury. I mean, it takes a lot of time to put this together. So I'm just saying that not only for this nominee, but everyone in general has to be on the record that that's my, because if I'm asking you, if you were in college and I said, okay, I want this paper 2 days ago, how ridiculous is that? So this is what we're asking nominees. So I do want to say that. And I do want to say that I met at length with the nominee, and we did talk in length about fathers' issues, because you know I do feel that fathers in general are not getting a fair deal. And I'm not a lawyer, but I know, and from my life experience, that I've seen friends and family. So I understand that, and I'm pleased with her response, and I'm sure that as you observe this hearing, you'll be happy with her response, because she has represented a lot of military people with a divorce, custody, and so forth. And when we discussed this in Lent, I was very pleased at the end of our meeting, her position on custody and the father's position.
That's very good news.
I want you to know.
Yes, and I appreciate the time factor that the nominee is under. We learned of the hearing today only following last Wednesday's hearing, and I sent an email to the nominee
And you knew before
on Thursday
her.
or Friday.
And Joe, you knew before her she was going to have a hearing today.
Okay. So I understand the time factor. There's still, before you vote on it, there's still another week. I would hope the nominee would take a few moments to at least look at the
Hopefully councils will finally listen and say, give this person 2 weeks. Don't have them expected to give a questionnaire 2 days ago, you know? So thanks a lot, Joe, for coming. Appreciate it.
Does anyone have any other questions?
Any questions? Thank you, no questions.
Thank you.
I just want to make a point. I'll take a shot. I was the one who scheduled the hearing in a week's time. Harvard University, Georgetown Law School, come on. You could have filled that application out in a half an hour, and let me say further, this vacancy has been vacant since February '09. It's too long. We need someone in the Rochester District Court as soon as possible. Any other questions? Thank you. There being no one in opposition other than Joe's statement, at this point, we'll hear from you. If you could give us a brief presentation as to your background and why you'd like to be an Associate Justice of the Rochester District Court.
Yes, thank you. I really want to thank, first of all, the witnesses, all my friends, colleagues who came, Judge Hinkle. It's really important to me, and it's not often that you get to hear people talk about you and what they think about you in such honest terms. And I, am, very, very moved. Thank you so much. And unlike Lauren said, it was actually her that all of my clients liked. Much more than me. I also want to thank my partner, Janine Cook, who is here, did not speak, but is here in support and is always supporting me. I am, as you have heard, a Marine and a lawyer, in whichever order you might like to say it. I've been a Marine for 15 years, and I've been practicing law for 14 years. I am from Chicago, so I'm somewhat of a transplant, even though I've been here quite a while now. I grew up in Chicago on the south side. My household consisted of myself, my mother, and my sister, a single-parent household with a mother who's working very, very hard to make ends meet as a dental assistant. Despite our meager surroundings, she definitely put an emphasis on education. And there was really, for me, no way out of education and getting a good one and doing well. At least I didn't think so at the time. And she set the bar very high for me, and I appreciate that. I went to high school, grammar school and high school in Chicago. Went to Hyde Park Career Academy, if anyone's familiar with it, on the south side there. I graduated in 1988. And I was only one of a couple of people from my high school, I think even up to that point in years, that applied to and I got accepted and went to an Ivy League school. It wasn't the norm for my school, my neighborhood, my community, and it was very special. And it was a big leap for me to go from Southside Chicago to Boston, to Harvard, which is different too from Boston, and settle in there and make it a home as well. While there, that was when I decided upon law school, and I knew that I loved being an advocate, even at that point, for people. And I took on issues in college. I mean, I think that's part of what college is about, to argue with people and debate and do this kind of thing on the campus and between college groups and organizations. And I felt that I was a good communicator, and I wanted to continue with that. I applied to Georgetown and left Boston at that point, went to DC. I arrived in DC the first day of orientation at Georgetown with no apartment, hadn't been to DC ever before, but I was ready for class, if nothing else. And so I started and had a great time at Georgetown. And I thought that it was a huge school, it was a great experience. I learned as much as you can learn in law school about being a lawyer, which probably is not that much, but I very much appreciated my experience there. And while I was there, I just one day had this thought that, okay, great, I'm in law school, I'm going to be a lawyer. What else is there? What else is there? That just didn't seem to be enough. I wanted another career, another part of a career that was somewhat physical in nature. I actually applied to the fire department here in Massachusetts. And eventually I settled upon the Marine Corps, which was another big leap and was not something that was normal for people in their second year of law school. I accidentally found out about the officers program, actually. There was one other Marine at the school who sort of illegally advertised the program, and I found out about it and became very interested. I discovered my desire to serve the country, to learn to be a leader, to acquire all the things that I thought that Marine officers did acquire, and I applied to the program at that point. I went to officer candidate school after being accepted to the program in the summer after my second year of law school. So when most people are summer associates at firms and trying to move in that direction, I went to OCS and was sort of crawling around in the dirt for weeks and weeks, being run to death. But I came back to school. I was commissioned and released on the same day so that I could continue school, my last year of law school. I came back to Georgetown a Marine, and that was quite a transformation, physically, mentally, emotionally, and everything else. And it has been such since then. I have fielded lots of questions from that moment forward. Why are you in the Marine Corps? Why are you doing this? Even of the Marines who I'm out in the field with saying, why are you here? We know why we're here. Why are you here? And I always said, I'm here for the same reason, actually. There isn't a different reason. I want to serve. I want to do this kind of work. I want to lead people. I want to be instrumental in the lives of people who go in harm's way for the country and make it back. And once I graduated from law school, unlike most new graduates, I was not looking for a firm job or really looking for any work. I knew that I was going on to active duty, which took some of the pressure off of me in some respects. But it was also very stressful, given that it was a different path. I did not have many people to look to who had done what I was doing in the order that I was doing then, or even at the same time, or anything. And when I graduated, I came back to Boston, and I worked, as Jerry Noguchi was saying, for the Norfolk County DA's office when Bill Delahunt was the DA. I got sort of my grounding in that court. As you know, in the district courts, as DA, you're in court every day. As an assistant DA, you're on your feet all the time. And it was a great experience. I did get to do trials in that court. I stayed there for approximately a year while I was studying for the bar, taking the bar, waiting for results. Because it was only at that point that I could go on to active duty as a judge advocate for a full tour of duty. And so when I did get those results, I left the DA's office after about a year and went down to North Carolina, down to Quantico, Virginia for more training, the basic school, which is 6 months long, and then on to what would be my job in the Marine Corps for the next 3 years, which was being one of the few judge advocates on the base at Marine Corps Air Station New River, which is a tiny helicopter base in Jacksonville, North Carolina. It is right down the road from Lejeune, which is much bigger and much more well-known for the Marine Corps. But I was the sole prosecutor there, and 15 squadrons, 15 helicopter squadrons, lots of young Marines, lots of trouble. And I got to prosecute a lot of cases. Did a lot of trials, mostly jury trials, what we would call members' trials in the Marine Corps. And I also got to do, as Councilor Bain mentioned, a lot of work for service members, other than their criminal matters, including their civil issues, which largely focused on family matters. They were, unfortunately, there were many cases of divorce and separation, and of course attendant to those circumstances are child custody, child support issues that I had to deal with from many different states because the service members were coming from all over, and also had to deal with the Marine Corps rules on all of those subjects as well. And I have represented, in that capacity, mostly men and fathers in their struggles to maintain their families, to pay appropriate child support, to have custody or share custody, or whatever the case was, or to just separate in a way that allowed them to do that and still continue with their careers without much disruption. So I feel that I did get a lot of experience on that side of things as well. When I came off of active duty in 2000, I left North Carolina and came back to Boston, and that's where I started with Dwyer and Calora, met Ellen and Lauren at that point, and it was really at Dwyer and Calora that I learned, I would say, how to practice law in Massachusetts, as opposed to generally or in the Marine Corps. And it is an outstanding group of lawyers at that firm, and I've learned a lot from Tom Dwyer on down to the associates that were there with me. And that was the point at which I began to practice in a more broad way, not just criminal work, what I call blue collar, which are what I've been focusing on in the last few years, the robbery, murder, rape, those types of crimes. And at Dwyer, we focus a lot on white collar crimes. I also got a chance to do a lot of employment law from the plaintiff side, representing individuals with Ellen Zucker, with Jody Newman over there, and got a very good grounding in that as well. And I would say that my practice was still at that point largely criminal, even though I was doing some civil work in addition to that. In 2007, I left Joeu FrisonHearingOctober282011878 and went out on my own practice. I opened a Frison law firm and started to work almost solely doing criminal work and focusing more on where my heart was taking me, which was to the larger criminal cases. One of which Judge Hinkle mentioned. I shared with her probably my most difficult case and most difficult moment in a case, and most difficult sentence in the case as well. And it is from those experiences, I practiced extensively in the district courts, in the superior court, and even some in the federal court here in Massachusetts and in Maine. It is from those experiences of being in front of countless judges, working with so many district attorneys, so many other private counsel, that I have gained an appreciation for judges, what they do, what's required of them, and I feel that, like Jeremy was stating, it is largely about temperament, and some of the givens are knowledge of the law, the ability to communicate, and I think temperament and the ability to take in both sides, just listen and really consider both sides of any matter, I think are not so common, and I think less common among people who are fierce advocates for one side or the other for many years. I feel that I do have both, do possess the ability to do that. I'm a good listener, I communicate well, and I would like to lend my voice and perspective to the bench in Massachusetts, particularly in the district court BMC setting, in which, as the witnesses stated, a very busy court with lots of issues, but still issues that are very important to the litigants that come before you, and not to lose sight of that. Without boring you anymore about my history, I do ask that you confirm my nomination, and I'm happy to answer any questions from the council that you have.
Thank you. Councilor American, do you have any questions?
No real questions. I was very impressed with your witnesses, very impressed with your presentation. I talked to Jeremy Busey about the innate quality of humility, and somebody sitting here listening to you, watching you describe your path. I can see what I need to see, and know that you'll bring to the bench the kind of quality that doesn't transform into the imperious quality sometimes we see. I think you have an amazing story of independence and sort of personal sense of yourself and what you want out of life and what you want out of your career and your profession. And I think that you'll do a great job on the bench. With all due respect to Councilor Ainella, I liked Jeremy Busey's answer to the question about would you reopen the evidence. I think that was sort of a layup if he wanted to tell somebody what they wanted to hear. And he didn't. And he told it like it was, and that is it's a discretionary thing. I wondered, as he was saying it, whether or not he's really talking about him or you. And now that I've had an opportunity to listen to you, I know that you would listen, and there's no default answer to that. You have to think about the circumstances and the posture of the case, and what's appropriate for the exercise of your discretion. And so, again, after hearing his explanation, again, I was going through my mind wondering what your answer might be. And I don't know what it is, but I suspect I know what it is. I think that the court that you're going to will be wonderfully served by what you bring, and I think it's a great nomination.
Thank you, Councilor Murray. Councilor Foley, any questions?
Just a couple of comments to take a second, because you got me thinking, Councilor, you know, and it goes to what we're talking about in court, it's temperament. And I just had a flashback from Councilor Nell said it. You know, when I was a young trooper on the road, the midnight shift was on my way home. I stopped the car in Worcester, and as I was speaking to the individual, another car went by me at high rate of speed, and almost took the door off of my cruiser and me. And I stopped the individual and I wrote a citation. You know, several months later, it came before the judge, and I had just come off a midnight shift, and I had waited for over 2 hours to testify, and the judge paid for me to get up there, and I don't think I gave the testimony. And after I gave my testimony, he said, "Only case dismissed, you feel to educate us in a public way." I never made that mistake again. But on the other hand, I walked out of there, I think the judge could have handled that a little differently. I think the message could have gone through either one of the assistant DAs or even one of the clerks and called me aside and mentioned it and everything. But it left me, even at that time, even thinking about it, to go back and say how important it is for people to start using it in court. And I think over a period of time, this other hearings we've had, how when we start dealing with the public, we start getting a little, maybe forget the personal touch, and same thing coming in over and over again, which you have an experience coming before you, especially at a young age, for maybe not a long period of time, but who knows what the future holds for you, especially if you're good at what you do. But it's something I try to say to the nominees that come in here, to kind of keep that in mind, that every individual that comes before you is an experience walking into that court, even for people that kind of use it on a regular basis. But one thing that we've been dealing with here that I do want to mention, Mr. Uranic mentioned it here before, and I will say this to you also, that you know, my experience on the state police at times, I have dealt with sometimes at 2 o'clock, 3 o'clock in the morning, where we're calling on call judge for a 2098 to be issued and so forth. And naturally, in most cases, the judge is saying, yeah, go ahead. We pass it on to the local police, so we're dealing with it ourselves. That too, I think, needs to remain in the forefront of your mind in dealing with these situations as far as 298s go. I think the law, there's a real dispute. I'm not an attorney, so I'm not going to try to say what the law is. There's a dispute between how the law is actually used and put in place between, I think, Fathers Coalition and maybe some of the people that sit on the bench. But I think what they're looking for more than anything, and which I would be looking for too, is for you to understand the importance of both sides of that. And that when a 2198 is issued, how important it is, not just for the fathers, but the mothers, everyone in that family, that the process can be expedited as soon as possible. But those are just my comments. You do have an excellent background. And I enjoyed listening to you. Apologize for being late. You just came down from New Hampshire and there was car traffic, so I missed Judge Hinkle and releases. Thank you.
Thank you. Councilor Rodriguez, any questions?
Thank you. Nice to see you again. I want to thank you for the time. That was unbelievable. The time went by so fast with you. I enjoyed it. And I want to thank you for your service. As I told you, my late husband was a Marine and a firefighter. So, you know, so some of the places that you've been, he was too. First of all, I was just so impressed with your background because I have always stressed that I look for, besides the qualifications and demeanor, but to have the life experience to bring to the bench in addition to the legal. And someone of your age, I wouldn't look favorably on to go onto the bench, but you have the ideas, more life experience and more legal experience to bring to this position.
than people who are, you know, have practiced twice as long as you, and much older, more mature, but you have it all, and I'm just so impressed. When, and I first want to say, and get this right out there, when we talk, and it's so good not to have an insider here, and that you said something to me that really touched me, and I'd like to repeat it. You said you want to earn it on your merit, or you don't want it at all. And you're not a personal friend of the governor's counselors. You don't share an office, as we've had a couple of appointments this past year with a governor's counselor, and that means a lot to me, because you earned it the old-fashioned way to get there. And I was impressed with your background, because we don't see people with that extensive legal background in criminal, you know, experience. And you had 80% criminal, 20% civil. I couldn't ask for more. Solo practitioner in, you know, Harvard University in Georgetown. What else can you say? You know, your mother must be so proud. Again, I'm just so pleased with the governor's appointment. I don't have a poker face, and I'm saying it now. This is a great appointment, and no counsel guided you to the process. I helped you do your questionnaire. You did it on your own, and that means everything to me. You have had cases, murder, rape, assault, drugs, sexual offenses in the military, as I said to Joe, that you have you have represented in divorce cases, custody. And I did talk with you about your percentage of representing men and women, and I think you said you represented more men. Yeah, and which we don't usually say. That's unusual. But I just in your publications on law and criminal justice and Guantanamo Bay, that was very interesting that you wrote on that. You're Lawyer of the Year, the Mass Lawyers Weekly chose you in 2008. So, I've said all that. You've been a prosecutor, defense attorney, and what I saw in you was the demeanor and the temperament that I want, that I would want a member of my family to go before you, because you are compassionate. When we talked, it came through. You are caring, and you're compassionate, and you listen. You listen to me for a long time. I just was very impressed. So if you just want to talk about some of your cases, I thought that you documented. That was very interesting. Can you just tell us, and your witnesses were great. I just wanted to ask you, because I know I think we covered it quite nicely when we met, but tell me how all of this comes together, your military, trials and cases, and you've had a lot of jury trials too, which some people don't come with that. So how do you think the trials that you've had in the military, helps you to be the unique person that you are to be a judge in Massachusetts?
Thank you for that question. It's a good question, because I don't find that many people in my practice here that also practice military justice, military law in any forms. It's not that common, at least in Massachusetts. But I think that that form, which is technically federal, the military courts, and so people leaving there with a conviction, even if it's for disobeying a superior, it's a federal conviction. That's important, and it's a big deal for service members who are not only subject to all the regular laws that we are. You can't hit people, you can't assault them. They're also subject to a whole other set of rules that they can't break and that may be criminal in nature. And I think that has given me a lot more sensitivity to all sorts of circumstances that people find themselves in. People miss movements, they miss deployments, they disobey, they talk back, they do all sorts of things. They don't want to play anymore for different reasons. And you have to deal with that, not only whether you're an advocate for them or you are prosecuting them trying to in a position of trying to decide whether to prosecute or what to do in situations like that. And I think I've been in positions, especially within the Marine Corps, as I'm a major in the Marine Corps, and so once you get to a field grade level in the organization, you do have a lot more responsibility for people and decision making. And one of my last stints on active duty was in 2005, and it was difficult for me because I went from Dwyer Calora solely, advocating for defendants, mostly criminal cases. I went from that, just sort of yanked out on orders to be mobilized, to being the supervising prosecutor, what we call the military justice officer, supervising prosecutors and making the prosecutorial decisions, or at least giving that advice to commanders. So it was very difficult to go from all defense to now you're the main prosecutor for 6 months in Okinawa, Japan, of all places, and handling all those cases. And I think that experience, as well as all of my experience in the role, has given me just a greater appreciation for people coming from all walks of life. Some of the things that we talked about, the litigants before you and what they bring in. They're not just the sum of who lie there in front of you. They're a whole person. They have maybe older than me, coming before me, and have a lot of experience in matters that have brought them here, brought them to the court, that I think have to be considered and taken into consideration all the time. I also think that the Marine Corps has given me a lot of leadership ability and the ability to manage people and difficult situations. That's part of the whole harassment package that the Marine Corps gives you, so that you can be able to handle those kind of situations. And I think that that's a good skill and a required skill, really, especially for a court as busy as Roxbury or any of the EMC courts or district courts in Massachusetts, at least. So I think it's given me a lot to learn.
Well, it's been quite a journey from Mississippi, hasn't it?
Yes.
Well, as I said, it was a pleasure to meet you, and I really commend the governor for this appointment, and I just hope there's more coming. I know that not a caliber of this, I can't even imagine all this put together in 8 years, and I'm grateful to the governor. Very pleased to vote the nomination next week. And thank you very much. It's certainly your experience in the military brings a different perspective to the position that I haven't seen before. So I thank you for all your service.
Thank you.
Thank you, Councilor Van. Just a few quick questions. You heard my question to the Assistant District Attorney Bucci. My very, very good friend, Councilor Foley, you heard what he had to say as a police officer on the other side there. Tell me, what do you think the role of a judge is in a jury trial? Or in a jury trial? Then even in a bench trial, it really should make a difference. What is the role of a judge? Because you've had two situations here. You've heard, what the judge did in his case, and you've heard he wasn't happy. And in my situation, I like when a judge doesn't get involved, and I have great respect for him, and I mean that honestly. So what do you think of the role? These are sort of two different situations here. One judge here doesn't get involved, another judge. So what do you think the role of the judge is?
I think that I do think that the judge is involved, I guess, if we're using that term. I certainly don't think that the judge should try a case, particularly if we're at the point of a trial. I feel very strongly that counsel on both sides need to be very strong, know their case, be able to present it in the best possible light, have all their ducks in a row, whatever that means for their particular case, so that the judge is able to focus on the law, the jury. As you know, in a jury trial especially, there is a lot going on at one time, including the trial itself and that particular defendant, the jury, other members in the court, and other cases that may have to be tended to. And I really think that if on a case-by-case basis, the judge really has to be able to identify when counsel both are in a position to make it happen, try the case, try it to the best of their ability, and that all issues and facts and everything that should come out from both sides. And in that case, obviously the judge is able to step back and let that take place, instruct the jury, deal with rulings of law and issues that come up between the lawyers. I think that is the primary role. I do think, however, there are times at which, if you see that a particular counsel is not bringing forth the issues that need to come out for his or her side, that you may actually pull counsel aside or make it known that this is an issue and we need to deal with it. So, although it is not the primary role to try the case, obviously, or get involved in mistakes or strategy for either side, I do think when there are important issues that need to come out, that the judge is sort of the last person in the courtroom who has to say, okay, this is an issue. Not sure why it hasn't come out, but let's deal with it.
So, if it's my understanding, whether it's a criminal case or a civil case, you would take the position that if either side didn't bring out an issue, you may put them aside and say, you know what, I think you should bring in the fact of causation. I mean, this is a civil case. I mean, I know the person got hurt, but really causation could not be an issue. So you would really play, that to me is a very active role.
I think that I don't know that it's an active role. I wouldn't call it an active role.
Well,
And I don't mean, sort of going in behind counsel and saying, with the checklist, you didn't do this and you didn't say public way and you didn't say whatever, the technicalities. But what I'm talking about are, if there's an issue that the jury should hear, in my estimation, in terms of, in order to fairly decide a matter, then yes, I probably would pull counsel aside. Now, it's still counsel's decision whether to bring that in, present it, whatever. But I at least want to alert counsel to what I think the main issues are and the important issues, not every little detail that they may have forgotten or pieces of strategy that I disagree with them on.
yeah, no, and I appreciate that. With all due respect, I disagree. And I'll give you one more example. I strongly disagree. Like, take a civil case, and you think it's important. It probably is important for the jury to realize that this guy's got 5 back surgeries and had 25 different claims. And guess what? The insurance company attorney forgot to mention that he has these prior problems. That's an important factor. And if you bring that lawyer aside, say, in your memos, what did you forget? Oh, yeah, thanks. I think it is important. And I personally, I appreciate your answer, but I don't, I think if a judge gets involved, you're really playing a significant role in the outcome of a trial, whether it's a criminal trial or a civil trial. The same thing could be for an attorney who represents the defendant. Why don't you ask that witness this question? So just my opinion, but I do appreciate it. I think it's the role, it isn't the role of a judge to get involved. I sort of like the judge in Counsel Foley's case there where he didn't get involved. That's just my opinion. Now you've been assigned to the Roxbury District Court, but you may never spend a day in Roxbury. You go everywhere. Assume you go to, let's say, I don't care what court, Hingham District Court, and the policy of the chief judge is first offense, drunk driving, we give him X, whatever X is. I don't do, like I said, I don't really go to court, but let's assume that it's, 30 days in the House of Correction. I don't even know if that's possible. In other words, that's the policy of a particular court. And you're not assigned to a court. This week you're in Hingham, about 3 months in Hingham, then you're going here. Will you abide by what the chief judge and obviously the other judge in the court have been doing, where you're just filling for a week or two, where they're more familiar with the community, even though you may disagree with that philosophy?
If I were to go to another court that in which a particular judge or a group of judges have a sort of a policy on how they normally do things, if I'm in the court, I'm going to be who I am in that court, just like I would be in Roxbury or anywhere else. I can understand that courts, especially smaller courts, do have some normal sentences, normal processes that they might do, the ways in which they might handle certain cases. However, I wouldn't be inclined to follow another judge's particular sentencing philosophy or anything like that, unless I agree with it for a particular case that's in front of me. And so I don't think that those decisions should be made just based on this is what we always do. I don't agree with that kind of decision making on cases, and I think that each litigant in front of you has to be considered, and for their matter, and what's in front of you, whether you're in Roxbury, Hingham, or if you're holding court out here on the steps, it really doesn't matter.
You've been a prosecutor in the Norfolk County District Attorney's Office, a prosecutor in the Marines. I've been here a long time, longer than anyone. Whenever we appoint someone who's an assistant DA, U.S. attorney, FBI, the first thing my Boston lawyers say to me, oh, another prosecutor, come on. Once a prosecutor, always a prosecutor. A Marine, a tough person, okay? And you've got to give that person a fair shake, not an unfair shake, but you're going to give that person an unfair shake. I mean, I'll be perfectly clear with you. I mean, I get nervous when I see U.S. attorneys, assistant district attorneys. Some of them have been fine judges. Some of them, you know, a prosecutor. You don't have a chance. Okay, I'm sure you were at Dwyer and Calora, and you go in front of Judge so-and-so. Oh, we got the worst judge. That happens. What is a Judge Friesen going to be like? I mean, we're not going to know this. I mean, community service, jail time. I mean, obviously every case is different. We don't have anyone here that we prosecuted in the Marines. I mean, that would, you know, we would have got, what was she really like? So give me a sense, what is a Judge Friesen going to be like when it comes to sensitivity, compassion, giving folks a fair shake? I know you're going to be tough, and I know you're going to be, you know, you have to apply, you know, the law as it is, but I'd like to get a sense on that issue.
Sure. Well, I hope you won't put too much stock in toughness. The Marine Corps is very tough, that is for sure. But in addition to prosecuting, I certainly started out with prosecuting cases, Norfolk County, Marine Corps, and sort of got my my first trial experiences that way. However, since 2000, I've been defending people, and that's a big transition. It's important, I think, for lawyers, whether they're trying to go to the bench eventually or not. I think it's important for people to get experience on both sides. And even people coming right out of school, I tell them when they ask me, you know, what should I do? I say, you know, get experience on both sides if you're interested in doing trial work. I am very sensitive to litigants, to the lawyers, you know, just in terms of schedules. You know, it has to work, I think, in a court. Everyone has to be heard. I think that if I'm known for anything, I would like it to be that if you come into the court and I'm sitting, that you know that your matter is going to get a fair shake, that you're going to be heard, even if you have, you know, an argument that you think or some people think is pushing the envelope or unusual. I like to think that you won't be able to look on a bench and say, I know I'm going to get this or that out of her, or we can't get this. I would not operate that way. So I think that if anything, I like to be known for making decisions based on what both sides bring to the table and not based on some notions that I bring in with me. So.
Thank you very much. I don't have any further questions. Councilor Timothy, do you have any questions?
I don't. Thank you, Mr. Chairman.
Thank you. Councilor Foley, we'll get a follow-up there.
I have to follow this up. My friend Councilor, I know some issues, but I have to say this. I hope you never appear in that seat while I'm here in the future, because definitely, you just got to finish saying, Councilor, what bias, honestly. I've sat here now for 3 years, and there's been considerably a lot of defense attorneys that have come through here, which I voted for. And I think you take the person as an individual, not lumping all us right-wing people, these conservative people out there, and say, oh no, just because they're a district attorney. I think the points come up before that, you know, a lawyer is a lawyer, and there's both sides and roles that have to be played. And be careful not to put somebody into a position because of the role they play, that all of a sudden that's the way they think, is lock them up and throw away the key. And I think there's a lot of people out there that have shown that. We come from both sides. And in particular, I think one of the things we have a question about is maybe an assistant district attorney out there doing domestic abuse cases and all of a sudden being labeled as a person that might be not friendly to men. So I have to just respond, because that issue has come up, Chris, a number of times, that just because you work on the government side does not necessarily mean we're all gains cards here. And that's not capable of serving. So
I didn't want to give you that impression there, Councilor America.
Councilor Calvin?
We'll get I think of one follow-up.
All right, thank you. No rush. Just wanted to follow up on a couple things. And, you know, we're asked by Councilor Heinel about whether somebody might say the policy of this court is we give 30 days to everybody. I can't imagine you're ever going to enter a courtroom in any part of the state where somebody's going to have a policy on what the sentences might be.
Quincy District Court had that, Tom.
Well, that hasn't been recent, I'm sure.
Well, they actually, I mean, we'll get it later.
Kramer?
Yeah.
I mean, but that was 25 years ago. So I don't think that today's proper judges are that way. But the point is a good point, because there is something else that goes on, and you're going to encounter it. And I think that Councilman Heinel's point was really important, and that is, and you get it just by your answer, is that you are sovereign within your court. Nobody's going to be able to tell you what to do. But there is this drumbeat for what's called metrics inside the court system, and you're going to hear it loud and clear. And as a newcomer, you need to remember that you are sovereign, and that while case management metrics are important, you're still free to make your own decision about whether or not a continuance is appropriate or how to manage a case. And so I think the point is well taken. Within the four walls of the courtroom you're sitting in at any time, there's very little anybody can tell you what to do except when to start and when to stop. Your comments about being involved, and you were asked a question about whether or not the jurors, the attorneys forgot to mention the 5 prior acts or reasons. Is that the kind of case or a set of facts that you think you would want to get involved in, or is there something else?
No, thank you. That you know, that kind of factual, you know, bringing out facts that councilman, I really wasn't talking about those, but you know, if there is, it's hard to give a good example, but if there is a legal issue that needs to be debated and decided, say, before the jury gets the matter, or if there's something that is because of the
like
jury's,
the voluntariness of a confession issue
exactly,
that has to have
something large.
it's in the facts, but has to be positioned the right way for jury to decide.
That's right.
Yeah.
That's right. Some larger issue, certainly not reminding counsel of facts that they may have. Nothing that small. So I don't think that the judge should get involved in that level of detail on the case. So I did mean the larger issues that would be required for the case to be determined fairly, either by judge or jury.
Thank you. Councilor Calhoun, any questions?
Yes, I do, but something came to my attention this week, and it has to do with the 209As. I know you asked about that previously before you came here, but in this particular instance, person A struck person B and broke the nose of that person. If the person that could be was arrested and for assault and battery by the police, and that person A went down on a different district court where this didn't happen, where that person lived, and got a 209A out. Now, person B goes and gets a 209A against person A in kind of a defense move. And then I'm kind of concerned with the fact that these 209As are now being used as a legal tool and a weapon. But one against the other instead of the original purpose, which is protect the lives of the spouses and children. Do you have any views on that?
Do I have any views on how the 209Es are used? I don't have any views that go towards, any metrics, I guess you would say, how courts are issuing 209As or how judges are issuing them as we speak. I do feel very strongly that 209As should be considered on a case-by-case basis, and not just because it's available on an emergency basis, that means it automatically is given. It is very hard, I think, for anyone to, especially with something like a 209A, which is a protective measure. It's a serious thing. It's not just, in my opinion, something you just walk in and do. And I think that in each case, the judge really needs to know as much about the situation as possible from both sides. What happened, why the person is in fear for their safety, any background, history of violence or anything. Just as much information as you can get, and to decide whether to even issue one. I don't think it's something that should be given out just because it's asked for. I do take the requirements of the 209A seriously. I have represented people seeking them, and I've probably represented more people seeking to not have them issued against them, or seeking to end them or shorten them. So I do understand the standard, and I take it seriously as an advocate when people want to seek them, want to end it, and being frank with them about what that entails and why. And also, as a judge, I would take it very seriously. I don't think it's something just to be doled out like candy, but it also serves a purpose in a lot of cases. And so it's hard to say as a philosophy what I think about them. I think that they are part of the law. I would follow the law and try to use the standard in each case so that if I'm issuing one, I'm sure that this person is in favor of safety. And if there's some basis, so, and whether it is what you might call a cross complaint or not, I think the determination, the standard is the same. Whether someone has one out against them already and they're seeking one, the standard doesn't change for them, whether they're seeking one and there's one against them already or not. It is somewhat messy sometimes, just like cross complaints for assault and battery. Same kind of gamesmanship that you're talking about sometimes may be played, but it's still on a case-by-case basis for a magistrate or a judge to determine whether that complaint issues for assault, whether 209A issues. The standard doesn't change, so I would just use that in every case.
Thank you. No more questions. That will conclude the hearing. I was thoroughly impressed with the folks that came on your behalf. What an educational background you have, what your work experience. It's pretty astonishing. And I want you to know that when your name comes before the council next week, I'll be more than happy to put it forward for your nomination to the BMC Rockford District Court. I think it's going to be a great asset to the court, and I wish you the very, very best.
Thank you very
Thank
much.
you.
Thank you.